Good afternoon, everyone. Good afternoon. How are we doing today?
Hi, good afternoon. Fine, thanks.
Great, great, great.
How are
Okay,
you?
I'm hanging in there. Okay, so today we're going to be beginning our discussion of causation. So you guys will recall that at the beginning of the course, we talked about how a tort is a duty of care, breach of the duty, and damage resulting from the tort. So this week and next week, we're going to be talking about what we mean when we say resulting from. Okay, so that's the subject of the next 2 weeks, are those two words. Now, the standard for causation is what's called but for causation. Now, if you're wondering what's a but for, I'm not going to give you the punchline. But the issue is that we only allow damages to be recovered, right, if the harm is fairly traceable to the defendant's negligence. Okay, so the first step in that process is determining, would the harm have happened if the defendant's negligence had not occurred? Would the harm have happened if the defendant's negligence had not occurred? Okay. And if the answer to that question is no, then liability can be imposed. So, would the harm have happened? No, liability is imposed. And I want you to remember that in order to get to the question of causation, you have to already have found duty and breach. Okay, so there was a duty of care, the defendant breached that duty of care, and now we are asking the question, did the harm result from that breach of the duty? Okay, now, one of the things that I think is important to keep in mind is that it is not necessary, right, that the particular kind of harm that the plaintiff suffers was likely. All that's necessary is that the class of harm that we're dealing with was likely. So let me give you two examples that I think sort of draw this boundary very nicely. Okay, so on the side of the class of harm being likely, if you have a plaintiff who has been injured and is walking with a cane, okay, because of their injury, and their cane gets knocked out from under them and they fall and injure themselves again. Some courts will hold that defendant liable for those additional injuries because they result from the ability, the plaintiff's inability to walk without the cane. That was the defendant's fault. Okay. You'll also see courts that will point the responsibility elsewhere, but we'll get to those later. Okay. On the other side of the line, if you have a defendant who's a property owner and the property is not developed, so it's sort of sitting fallow, vandals come onto the property and set a fire that damages neighbors' property. That would not be a class of harm that was likely enough to hold the defendant responsible for. Okay, so do you see what we're talking about in terms of the boundaries of causation, right? And this isn't remoteness, right? We're going to talk about remoteness next week. These are situations where the harm is proximate to the breach of the duty, but there's this question of, has the causal chain been broken? So are we clear so far? Do we see sort of how the boundary works conceptually?
Yes.
Okay, I'm seeing a no. What's your confusion, Tia? One second, I'm just. So Tia, what was your confusion?
I only got to the point where you were talking about the duty. For causation to happen, there must be a duty and breach of the duty. That's the only part I reached.
I'm sorry, say that again. You're
Oh, okay.
you
can
were a
hear-
little soft in my ears. Go ahead.
You can hear me now?
Yep, I've turned you up.
Okay. I only reached the part when you said causation equals like duty and there must be a breach of that duty. So
Yeah. So if we're dealing with a causation analysis, duty and breach have already been resolved, right? So the defendant has already lost on those issues, and we're now to the point where the defendant is saying, well, look, the harm that was caused was the harm that resulted did not result from our breach of duty. And so the boundary between this doesn't turn on the defendant's breach causing this particular sort of harm. It just has to be some sort of a class of harm that's going to be likely. Okay, so our injured plaintiff walking with a cane is absolutely, like, the possibility of falling is a known possibility, right? That's something that happens. And because people aren't as dexterous with a cane as they are with their own 2 feet.
Mhm.
And on the other side of that boundary, right, plaintiff fails to secure their property, and vandals come onto the property, set a fire that damages the neighbors. That would be a situation where the class of harm would not be likely enough to impose liability.
So does liability always have to be to so does liability, the likeliness of harm, that has to be like an element that they have to prove, or not all the time?
So I think that you're asking a question that has a broader
Okay.
a broader thing than and I want to explain what I mean by that. There's a broader issue here than what you're asking, because what you're asking is really about are these rules things that are going to come up in every case that a torts lawyer deals with?
Mhm.
And the answer is no, right? There will be cases where causation isn't contested. Okay, there will be cases where even if you're contesting causation, you're not necessarily contesting the class of harm issue. You may be contesting some of the other challenges to causation that we're going to talk about. And I think that the the problem is a bigger one than this, and this isn't a problem that you caused or that you're responsible for in any way. This is a problem with legal education. We teach you guys legal rules using this selected sample. Okay. And we say, you know, these are cases that tell you the principles. But what is not necessarily communicated very clearly, for example, this is the first time that I think I've said it in this class, is that not every issue is going to turn up in every case. And so one of the things that you really have to be capable of in, you know, sort of in talking to a client is figuring out what issues are actually going to be relevant to the case. Okay. And so you have to, that I think is a really important distinction. So Tia, does that help? I feel like I'm rambling actually, but does that help?
Does help. It does
Okay.
help. Because I was
Okay.
wondering if like the likeliness had to, like you said in the other stuff with the cane, it's likely that they would fall if anything
Yeah.
happened. But the likeliness for the
Yeah.
for the vandalize. Okay.
Exactly. So the hard part of the practice of law, and the thing that you sort of have to be able to do in your head on the fly, is figuring out what are the things that are going to be important in this case, so that you know what to research and you know what to look up and track down. There's a private message in the chat. Couldn't the property owner, right? So this is about the hypothetical of the property owner with the vandals. Couldn't the property owner foresee that another house that is in close proximity may be burned as well? I think the answer to that, based on my, because this is a hypothetical from an actual case, right? I don't have the case name handy, but it's a case that I reviewed in preparing this lecture. And if my understanding of the rationale is that the defendant could be expected, right, to see that vandals would come into the property and damage their property, right? Anything that was on their property. So they might have been liable to, you know, if people had been storing stuff on the property owner's property, they might have been liable to them. But the notion that vandals would set, because the specific facts of the case are not that like the vandals came onto the property and stood on the property while they burned the neighbor's property. No, they set a fire on the property owner's property and it spread. Okay, so that's the part that I think may be missing, that that the court sort of said, okay, this was not a class of harm that could be foreseen. So does that help to the person who sent me that question? Does that help? It can be strange, right? Sometimes these cases, like, they come out in ways that don't necessarily make a lot of sense. Okay. So another question from Joyanne. If I fell at my place of work and suffered severe back pains and soft tissue damage due to wet steps, my company is liable. If the wet steps caused your fall and your fall caused all of these injuries, then yeah, company's probably liable. Now, I will say this, just by way of comparison, I do not know that anywhere in the Caribbean this is the case. In the United States, they have a system called workman's compensation, where the employer pays the state an insurance premium, and the state pays for pays the costs for workplace injuries. So the Caribbean may have something similar. in the event that they do, those sorts of systems are usually exclusive remedies. So you can't sue your employer. You have to take the workman's comp. The question is there, if there's a visible wet floor sign, right? Rudolph's absolutely right. Those are issues that you'll learn about in your third year when you take employment law with Mr. James. And absolutely, in the absence of, so the way that workman's comp works, and Colette is making the point that Jamaica has a workman's comp system, so I will expand on it briefly just to lay it out. The way that these systems usually work, and I don't want to say that, I say usually because I have not reviewed the Jamaica Act, but usually this is how they work. In exchange for the state assuming liability for the insurance premiums, workers get strict liability. So the worker doesn't have to prove a failure to take reasonable care, like a wet floor sign or some sort of instruction not to walk on the wet steps, right? The fact of the injury at work triggers liability. Okay. And then the state sort of takes over from there. So the employer gets some predictability in that they don't have tort judgments against them. They just have their insurance premium, and they get relieved of the duty of care, right? They no longer have to provide any sort of signs or disclaimers or warnings, but they do have to pay the insurance premium. And the workers get certainty of recovery, right? They don't have to prove negligence. They just have to prove that they were injured at work. But they lose the ability to get great big judgments. Okay, typically workman's comp recoveries are fairly small compared to what you would get in a tort environment. Okay, so Joanne, do you feel like that answers your question? Joanne? Okay, great. So usually causation is fairly straightforward, right? We have one thing that could have caused the harm, and we sort of move on to remoteness, okay? And we'll get to that next week. But there are some situations where the but-for analysis comes apart a little bit, and the doctrine has to be modified. So let me talk you through these, okay? And there are more or less 3 of them, okay? The first one is an intervening cause, okay? An intervening cause. And what that means is that we have the defendant's action, and then between the defendant's action and the injury, there is some second action by a non-defendant that causes the injury. Okay. Usually the non-defendant in question is the plaintiff. It's not always, but usually it's the plaintiff. And the reason for that is if the non-defendant who committed the intervening cause isn't the plaintiff, well, you just add a defendant to the lawsuit, right? You sue the other non-defendant. And so this is the example of this is in that case doesn't explain this. I will talk about that. I'll talk about that case in a minute. But if you have a third party, right, some other person who's neither the plaintiff nor the defendant who acted, their action may still be an intervening cause. that would relieve the original defendant of liability. Okay, so what this actually means, right, is if you have an intervening cause situation as the plaintiff, you can actually find yourself in what I like to call a game of let's you and him fight. Okay, where you can convince the two defendants to each point the finger at the other, and then the finder of fact, you have a much simpler case to prove because the finder of fact gets to award you a judgment, and they just have to decide who's on the hook for it. Can be difficult, right? Sometimes defendants coordinate defenses, and that doesn't work because they're watching out for it. But it's absolutely possible, right? And sometimes you can plead your case in such a way as to encourage that sort of behavior. Okay, so do we understand the concept of the intervening cause? How do we feel about this? Okay, getting some yeses. That's good. That's good. All right. Gonna give folks a couple more seconds just to. Okay, so we're getting an I don't. Where are you confused, Michael?
Could you explain the part with the whole go at it concept again?
I'm sorry. I didn't quite hear you.
Could you explain the concept of going at it? Just know the last thing that you spoke about with the two people,
Oh, yeah. Okay, so if you have an intervening call, if you have a situation where multiple defendants could have caused the injury, then you can, as the plaintiff, put yourself in a situation where the defendants are each trying to blame the other one rather than attempting to escape liability by blaming the plaintiff. Okay, so it's a situation where instead of looking for a judgment for the defendants, they're looking for a judgment for the plaintiff against the other defendant. So does that make sense? Does it make sense now?
Yes, it does. I understand.
Okay. So there are some circumstances where an intervening cause can be in place, but it doesn't. But the doctrine doesn't apply. Okay, and they basically amount to situations where the defendant who's been sued is responsible for the action of the person who committed the intervening cause. Okay, and so the four types of cases that involve exceptions to intervening causes are where the defendant has assumed responsibility for the non-defendant, where they exercise control over the non-defendant, where the non-defendant has in some way exploited a weakness of the plaintiff, and the weakness was caused by the defendant. So that's our cane using plaintiff who gets knocked down by a robber and has their wallet stolen. The original defendant could be responsible for the harm of the robbery. Okay. And the last category is where the defendant's property was used to harm the plaintiff, and the defendant should have prevented that use of their property. So that's going to be, for example, when the plaintiff gets run over by a delivery truck, and the delivery company should have prevented the use of their truck, right? Sorry, I need to change that fact pattern a little bit. Where the plaintiff gets run over by a stolen delivery truck, where where the defendant should have prevented the theft of the truck. Okay, so the defendant can be on the hook there in that situation. Okay, so so I've given you an example of the third and fourth exceptions. The first two basically, they're broader than this, but the most common ways in which those first two exceptions come about are when the defendant is basically the defendant being responsible for their employees and their agents. Okay, so do you understand the exceptions to the intervening cause doctrine? Yeah, exactly, right? A stolen gun is a perfect example of the last exception. If the defendant, if the gun was stolen due to the defendant's own negligence, right?
Sir, repeat the first two again.
So the first two are the assumption of responsibility for the non-defendant's actions and control over the non-defendant. Okay, so you can see what I mean when I say that most of those cases are going to be the non-defendant is an employee, right? Okay. So now do we understand the exceptions to intervening cause?
So when you say assumption of the non-defendant's own negligence, it would be like if you were like in the workplace and had the wet floor sign and the person still decided to walk on the floor and then they harm themselves.
Let me make a small change, right? You have the workplace with the wet floor, right? And you have the sign up that says wet floor with caution, and the plaintiff supervisor says, oh, that floor's not wet, that sign's old, we should take it down, and the plaintiff walks across it and slips and is injured. So that's what I mean. Does that make more sense now?
Oh, sorry, I said yes. Sorry, my mic was
Okay.
muted.
Okay. Have a private message just asked me to repeat the fourth exception. So the fourth exception is where the defendant's property is used to harm the plaintiff, where the defendant should not have allowed that use. Okay, so this is the stolen delivery truck, the stolen gun. Okay, you got it now? Okay. Next, there are two more of these. The first one is a superseding cause. Okay, so let me bring up the whiteboard and we'll talk about this very quickly. So, all right. So we have a timeline, right? So this is time. As a good social scientist, I always label my axes. So this is time, right? We have at time 1, right? So that's time 1. We have the defendant's action. And then over here at time 2, we have some other action. Okay. The idea behind the superseding cause doctrine is that injuries that are properly attributed to the thing that happens at time 2 should not be ascribed to the defendant who acted at time 1. Clear so far?
Yes.
Yes.
Okay. So, okay. I have a private message that we'll address that in just a second. So, once again, for those who need the repetition, right? Injuries that were caused by the later event should not be compensable by the defendant who committed the earlier one. That's the superseding cause doctrine. Okay? And the sort of classic example of these are when you experience an injury due to some sort of negligence, right? So, your hand gets broken by somebody swinging a cricket bat stupidly. Okay, these things happen, right? They're swinging the bat just to, swing the bat and feel their muscles work, and your hand is in the wrong place at the wrong time, and your hand gets broken. Okay. Subsequent to that, you develop arthritis. All right. The defendant, the cricket bat swinging defendant, would not be liable for damages that are properly attributed to your arthritis. So, does that make sense? Clear on this? Okay. So, let me...
Sir, quick question. What
Yeah.
if the injury helped create the environment for the arthritis?
Okay, so that's actually a really great question. And it's a question that the court had to deal with in the Baker versus Willoughby case. Because without sort of getting out in the weeds of the facts of the case, the plaintiff in the Baker case had suffered an injury from the defendant's negligence, and because of this injury, they were no longer able to continue in their chosen career. What that career was is not important. They undertake their new career. Okay. While they're on the new job, they are robbed and shot. Is the defendant, and the robbery and the shooting are things that would not have happened in their old career. Is the defendant liable for that? I just realized that my notes aren't clear on that, so I'm actually pulling up the worksheet myself just to make sure that I give you guys the right answer.
Is that not to remote?
Well, I'm about to tell you because I'm checking the case brief. So yes, their lordships concluded that if it had not been for the defendant's negligence, that the plaintiff would not have been in the position to get robbed. And so they held that the defendant's conduct did cause the damage. Now, Rudolph raises the issue of remoteness. We're going to talk about that next week. And certainly you're welcome to revisit this fact pattern once we've discussed the remoteness doctrines. Okay. So private message that I have, this sounds similar to an ongoing case I saw where an employee fell at her workplace. The floor was wet, unknown to her. She sued for damages, but the workplace was renting a room / floor in a building and said they weren't liable, and the workplace sued. The workplace said their landlord would be. Yeah, so this is a different exception to the but-for causation that we're going to get to in just a second. Okay, so having just checked the chat, we're now ready to move on. I can tell you the last category of exceptions to but-for causation is a simultaneous cause, and this is what you're talking about. Oh my word, I've blanked on who it was. Gemma. Damn it, you messaged it to me privately. I'm sorry, I did not mean to out you, Gemma. But this is that situation where there are multiple potential causes, okay, and it's impossible to determine who's responsible. In those cases, the court will actually impose a let's you and him fight. Okay, the court will say somebody is liable to the plaintiff. You both are responsible for the whole judgment. Fight it out amongst yourselves as to who's going to pay what. Okay, the term is joint and several liability. Okay, so everybody's on the hook for the whole judgment, and the defendants get to argue over who's paying how much. So the classic example of this is I was actually a little surprised when I saw on the worksheet that I was given to build off of, that the case that is used to illustrate simultaneous causes is not the case that I was taught to learn simultaneous causes, but it is exactly the same fact pattern. So the fact pattern is two hunters both fire into a wooded area, and they injure a third person that they did not see. It's impossible to determine which hunter injured the passerby, and so the court just says you're both on the hook. Okay. Jade asks, does the case turn into an arbitration? The answer to that is not necessarily. Arbitration is a private mechanism of dispute resolution. Okay, it's specific. It's basically private court. Okay. Dr. Hippolyte has taught a course on ADR that I definitely recommend to you in your third year if you're interested in that. Melanie, can you explain what you're asking when you say what was the terminology used? Oh, that's just my term. I said it's a let's you and him fight. So I'm sorry. That's my term. It's not. You should not. Please do not use that in a submission to the court. But yes. Okay. So what questions do you guys have about but-for causation and the exceptions to it. We're good? We're clear?
Excuse me, sir. I have a question, but it's
Okay.
about a case.
Okay. Go ahead.
So you like how Wagon Mound establishes the principle for, causation and limiting compensatory damages. They held that the defendants weren't liable because they wouldn't be able to reasonably foresee the damage to the wharf by them welding, meaning, the whole case about the spark from them welding ignited an oil spill, and then that oil spill in turn burned the wharf.
Yeah. I remember seeing the case. Yeah.
Yeah. And so they're saying that they wouldn't have been able to reasonably foresee the wharf would have been damaged by fire when they carelessly discharged the oil. But then when they applied this ruling in Hughes v. Lord Advocate, the judge for this case said that it's not necessary to distinguish between different physical injuries because the precise nature of the injury doesn't need to be foreseeable. And to me, that basically means that as long as there's a type of physical damage that could have been reasonably foreseen, no specific cause of damage or extent of the damage has to be distinguished. So is it that Hughes v. Lord Advocate overruled it? Because if that's the case, then in Wagon Mound, the defendants would have to be liable because even though they couldn't reasonably foresee the specific sequence of events which would have occurred in the damage to the wharf, they could have foreseen the type of harm that the wharf would have been damaged even from their welding without the
So the simplest the simplest answer to whenever you think you have found cases that contradict each other is judges do what they want. But that's not a helpful answer because within the legal system, right, we pretend like that's not true. And we have to argue like it's not true. So we have to find some sort of way to harmonize these cases. And I agree with you that these are too problematic. This is an issue. Here is how I would harmonize these cases if I was arguing it to their lordships. I would say that the wharf case specifically is about a situation that isn't going to be like, this is one of those, it's one of those situations that that involves so many steps as to be miraculous, right? Disasters can be miraculous too because, things have to be just so for it and everything has to go wrong. And so that's not a case that would result in liability because the possibility of discharging oil, it doesn't get carried away. We're engaging in welding, sparks go flying, and they ignite the oil, and it burns the wharf. Like this is a sequence of events that is so unlikely as to be unforeseeable. It's so hard to replicate this series of events that nobody would have expected it. That would be how I would argue it. And so I would say that the Hughes case that you mentioned doesn't overrule the earlier case, but the earlier case may sort of be limited to its facts. So does that answer your question?
Yes, actually, when you phrased it like that, it made so much sense.
Okay.
Yes.
Okay, let me make sure. Okay, a couple of questions in the private messages. So question about office hours. Office hours are on the syllabus and office hours are for you guys. We'll do whatever you want to do when you come to office hours. So if you have specific things you want to discuss, we can discuss it. If you want to get together and talk about cricket, I will be more than happy to be educated on cricket because I do not know anything about it. Okay, another question. Okay, I know I've put them on the syllabus. I don't know. I'll the answer to your the substantive answer to your question. Office hours are Mondays from 12 to 2. Office hours are Mondays from 12 to 2. In the virtual office on e-learning. And I will double check and make sure that that's corrected on the syllabus. A question in the private messages. Can you give an example of how the but-for causation comes in place and how the exception comes into place? Just to re-clarify. Okay, so let's do a very clear example so that we can understand causation. In a car wreck case, okay, the defendant had a duty to keep a lookout. We assume that the duty was breached because we wouldn't be arguing causation if we hadn't established a breach. The plaintiff was injured by being slammed into the steering wheel by the impact of the defendant's car. Okay, that's but for causation. Had the defendant not breached their duty of care, the plaintiff would not have slammed into the steering wheel because normal people don't just like beat their heads against things. At least not in my experience. Maybe yours is different. The exception comes into play. Still have a car wreck. Instead of the plaintiff slamming into the steering wheel because the defendant hits them, the defendant hit them because a third car hit the defendant. Okay, so maybe the defendant is careless, maybe they're not, but if it hadn't been for that third car, the defendant doesn't hit the plaintiff. So does that... Okay. So some folks are saying, and I'm gonna say this very briefly and then let you go because we're out of time. But there's some folks saying that there's a challenge with the categorization of an intervening cause as exceptions. So these three categories, I'm calling them exceptions because they are situations where but-for analysis breaks down. Okay. And I'm going to leave it there, but I will, on Wednesday, we'll expand on that statement a little more before we move on to the rest of Wednesday's topic. Okay. So the issue here is that but-for analysis breaks down, and then we have to use one of these other doctrines. Okay. So I will see you guys throughout the week. And certainly no later than Wednesday. So with that, I will let you guys go. So take care and bye.